Item 5. Principal makes oath that in the face of the unprofessional and willful nature of the woman calling herself Louise Henderson and the person calling him or herself Judicial Registrar Johnston, I wrote to their ultimate boss, the man calling himself Robert McClellan, who was also acting in the capacity of Attorney General of the Commonwealth of Australia at the time. The lawful notice to Robert McClellan is in the file attachment named as follows: 03 LN 2009 1022, notice to Robert McClellan .pdf. What I will now do is read this notice into the record, into the public record, and into evidence for this jury. This video will now transition to the reading of this notice to Robert McClellan. I am now going to read into the public record and into evidence the lawful notice I sent to Robert McClellan on the 22nd of October 2009. So, from free man commonly called Peter Andrew Nolan, standing in God's kingdom, and the address is just wiped out, to Robert McClellan, acting as the Honourable Robert McClellan, Attorney General, Attorney General's Department, Central Office, 3 to 5, National Circuit, Barton, Canberra, Australian Capital Territory, 2600, Australia. 22nd of the 10th, 09. Lawful notice to Respondent Robert McClellan, acting as the Honourable Robert McClellan, Attorney General, Attorney General's Department, Central Office, 3 to 5, Barton Circuit, National Circuit, Barton, Canberra, Australian Capital Territory, 2600. And this was sent to him under oath and penalty of perjury and full commercial liability. Let right be done, though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew of the Nolan family, hereinafter the principal, in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself Robert McClellan, acting as the Honourable Robert McClellan, hereinafter known as the Respondent. This is an affidavit with respect to the order of sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that he has received an order dated the 16th of June 2008, issued by juristic person known as Judicial Registrar Johnston of a family court dispute brought by Jennifer Marguerite Nolan with respect to the sale of the house located at 8 Schofield Parade, Pennant Hills, New South Wales 2120, and a copy was supplied to Robert McClellan. 4. Principal makes oath that at the time of this order, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that engaging a solicitor declared Principal a ward of the state. 5. Principal makes oath that at no time did the solicitors for Principal Watts McRae provide written documentation nor made verbal comment to the effect that the loyalty of Watts McRae and engaged solicitors was to the Law Society of Australia and to the Family Court by oath, and that they were acting in the best interests of the Law Society of Australia and were not acting in the best interests of Principal. 6. Principal makes oath that at the time of this order, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that they may, at their discretion, without informing Principal, engage in side conversations with other members of the Australian Law Society to create circumstances beneficial to the Australian Law Society, which would also participate circumstances detrimental to Principal. 7. Principal makes oath that at the time of this order, solicitations for Principal solicitors for principal Watts-McRae had at no time provided written documentation nor made verbal comment to the effect that they had a clear conflict of interest in that, as members of the Australian Law Society and under oath to serve the best interests of that society, their loyalty to the Australian Law Society conflicted with the interests of principal. 8. Principal makes oath that on the day of March 7, 2008, Principal met with the representatives of Watts-McRae. Principal makes oath that he had serious concerns as to the poor performance of Watts-McRae in his estimation, specifically with respect to refusal to pass along requested communications and specifically challenge the effectiveness of representation. 9. Principal makes oath that representatives of Watts-McRae made many verbal comments to the effect that they were working to represent Principal's interests, quote, effectively, unquote. 10. Principal makes oath that a Watts-McRae representative, namely Jacqueline Vincent, used words to the effect, quote, do you have confidence in our firm to represent you most effectively to the court, unquote, in asking Principal specifically if he had confidence that Watts-McRae would effectively represent Principal's best interests. 11. Principal makes oath that he was under the impression that every effort was being made by Watts-McRae representatives to assure him his best interests were being represented. 12. Principal makes oath that he felt at that meeting there was something wrong and that some deception was being perpetrated upon him. However, he could not comprehend what that deception might be. 13. Principal makes oath that at the time he was well aware that under commercial law, any contract or any performance of duties that are performed in deception as a result of deception are null and void and can be redressed via legal processes at a later date. Therefore, Principal determined that the course of action to pursue was to allow the deception to stand and to continue with the engagement of Watts-McRae and deal with the deception at a later point in time. 14. Principal makes oath that when he was asked to consent to the sale of his property, that he gave clear and unambiguous written instruction to Watts-McRae that he did not consent to the sale of his property. 15. Principal makes oath that his property was subsequently sold without his consent, subsequent to an order issued by Judicial Registrar Johnston, copy enclosed. 16. Principal makes oath that he has proposed remedy for what he sincerely believes was the unlawful sale of Principal's property because it was achieved by deceit. This remedy is a bill for the order placed to the value 10 times the proceeds of the order, namely 5.5 million Australian dollars. 17. Principal makes oath that he has written to the human being calling him or herself Judicial Registrar Johnston, also acting as a judicial person known as Judicial Registrar Johnston, and I sent it to the Garfield Barwick Commonwealth Law Courts building until I found out where that person was, and I sent another copy there. And I've written to them in a peaceful and lawful attempt to enter into lawful exchange of notices to address the issue of unlawful sale of property achieved by deceit. Principal makes oath that no known response has been forthcoming, and copies are enclosed. Principal makes oath that he has written to the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, in the Garfield Barwick Commonwealth Law Courts building in Parramatta, in a peaceful and lawful attempt to enter into a lawful exchange of notices to address the issue of unlawful sale of property achieved by deceit. Principal makes oath that no known response has been forthcoming, and copy was supplied to Robert McClellan. 19. Principal makes oath that he has filed a UCC1 financing statement to become the primary creditor and secured party of the corporation known as Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964. 20. Principal makes oath that he sincerely believes that he has a higher claim to all property of the corporation known as Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964, than has the private run-for-profit corporation known as the Australian Federal Magistrates Court, on the basis of being the primary creditor and secured party for that corporation. and a copy of the UCC1 financing statement was enclosed. 21. Principal makes oath that he wishes to engage in lawful exchange of notices and in a professional and peaceful manner, such that this issue of the unlawful sale of property be dealt with. Principal says not, signed by me, this 22nd day of the 10th month, that's a mistake, 2010, so 22nd of October 2010, near London, England. I had it witnessed and signed by 3 people, 22nd of the 10th, 09. Their signatures are hidden from the public. Notice of intent and proposed remedy. This section of this document provides a notice of intent and proposed remedy, inviting the respondent to peacefully and without dispute cordially resolve the matter at hand, that being the distribution of funds from the proceeds of the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. The 2 parties with whom principal has attempted lawful and peaceful communication have, to the best of the principal's knowledge, chosen to go into lawful dishonour. It is the principal's wish that this current situation be resolved peacefully and expediently. The respondent, acting in the role of Attorney General for the corporation known as the Commonwealth of Australia, carries responsibilities and obligations to ensure that subordinates meet their legal and lawful obligations or are penalised according to accepted norms of common law. These 2 parties being Judicial Registrar Johnston and 2 Federal Magistrate Louise Henderson. It is this principal's wish to engage in lawful conversation, parties responsible and accountable to the respondent in order to resolve this matter, this current matter of the unlawful appropriation of the property of the corporation Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964, which is fully owned and due to the human being Peter Andrew of the Nolan family. Principal, by way of the principal being the primary creditor and secured party for Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964. It is this principal's wish that the respondent respond to this lawful notice to nominate himself or delegated parties whom he will hold accountable for the proper and appropriate completion of the matter at hand. The time allocated for response to this lawful notice is 20 days from the date of issuance of the lawful notice. Should the respondent be unable or unwilling to enter into peaceful and productive exchange of lawful notices, or unable or unwilling to nominate an authorised representative to enter into peaceful and productive exchange of lawful notices in the 20 days allocated, the following remedy is proposed. 1. A penalty of 1 troy ounce of 99.99% pure gold per day be applied for dishonour and non-response. The Attorney General is the highest office in the land for this matter, and this principal expects the respondent to meet his obligation in ensuring his subordinates act lawfully in a timely manner. 2. Principal to convene a de jure jury to hear the facts of the matter, and the de jure jury to pass judgment on the respondent for failure to exercise his obligations to ensure his employees act in accordance with the common law of the land called Australia. 3. All said proceeds of property known as 8 Schofield Parade, Pennant Hills, New South Wales 2650, Australia, some $293,000 currently held in a controlled account at Watts McRae, contact Justin Dowd, be transferred to a bank account of the principal's choosing in a default judgment. 4. All time of principal and all incurred expenses which are required to be expended in order to pursue authorised representatives communicate with principal in an exchange of lawful notices will be billed directly to respondent as the authorised representative responsible for ensuring timely response to lawful notices of his subordinates. Principal advises respondent that non-response is considered dishonour under law, and that principal reserves the right to generate default judgments or convene a court de jure to pursue remedy should respondent go into dishonour. Non-response will be considered acquiescence. Yours sincerely, signed by me, that's my signature, 22nd of the 10th, 09. This concludes the reading into the public record and into evidence for this jury the notice to Robert McClellan of 2009-10-22. Thank you for listening. Item 6. Principal makes oath that I am in the sincere belief that the communications that were sent to Judicial Registrar Johnston and the man calling himself Robert McClelland were received by their intended recipients. I did not receive any non-response back. Item 7. Principal makes oath that on the date of November 24th, 2009, I went to a notary public in Parramatta, Sydney, by the name of Stuart Lawrence Niven. I asked him to witness my signature on a number of default judgments. One of those default judgments was addressed to Judicial Registrar Johnston. I subsequently mailed a copy of this default judgment to Judicial Registrar Johnston. The document delivered is presented in the file attachment named as follows: PAN DJ for payment of fee for house. Now what I am going to do next is, there were 4 default judgments signed by Stuart Lawrence Niven on the 24th of November 2009. Each of these judgments were directed to various people, 1 to Louise Henderson, 1 to Judicial Registrar Johnston, and 2 to my former wife, Jennifer Marguerite Toll. Now, what I'm going to do next is I'm going to include the video stream for all 4 default judgments. This is so that the jury for this trial can see that I took the time, trouble and effort to send lawful notices, to send default judgments, to go to a notary public and have the default judgments notarized properly and lawfully under common law, as well as the legal system of the Commonwealth of Australia, and these default judgments were presented to the people in question. The people in question have refused to answer these default judgments, refused to correspond in any way, shape or form, and are therefore in lawful dishonour, and have been so for more than 3 years now. This has been the time it has taken to organise new courts and new juries to come into existence in Australia. So this video stream will now transition to the reading of these default judgments for those 3 people, which includes Judicial Registrar Johnston. I shall now read into the record the notarized default judgments following on from the prior video presentation. This first one is actually for Louise Henderson and not for the respondent, Jennifer Marguerite Toll. However, I am reading it into the record at this point in time because I want you, the audience, in the Jennifer Marguerite Toll case, the audience and the jury, the public and the jury, to see that a default judgment was issued against Louise Henderson for the theft of my house. In the case with Louise Henderson, that information will be, of course, included. So I shall read this. I went and got the default notices notarized by a public notary, Stuart Lawrence Niven of 91 George Street, Parramatta. He's a public notary, authorised and sworn, practising in the city of Parramatta in New South Wales. This notice was served on Louise Henderson. Okay? So in the first instance, I will read the entire form and then I will just go through each default judgment. So each of these default judgments has got the same information at the front of it from Stephen Lawrence Niven. Okay, so Form 3, General Certificate as to execution of documents in presence of a notary as witness. So I signed them, he notarized them. Parramatta, New South Wales, Commonwealth of Australia. To all to whom these presents shall come, I, Stuart Lawrence Niven of 91 George Street, Parramatta, public notary, duly authorised, admitted and sworn, and practising in the city of Parramatta, in the state of New South Wales, in the Commonwealth of Australia, do hereby certify that I was present on the 24th day of November in the year 2009 and did see Peter Andrew Nolan, the person named in hitherto annexed, duly signed, seal and evidence, the said affidavit, and that the name thereto subscribed is in the proper handwriting of said Peter Andrew Nolan, and that the same Stuart Lawrence Niven thereto subscribed as the witness. Thereto is the proper handwritings of myself, Stuart Lawrence Niven of 91 George Street, Parramatta, New South Wales, Australia, the subscribing witness hereto, in faith and testimony whereof I have hereto subscribed my name and affixed my seal of office at Parramatta, aforesaid this 24th day of November in the year 2009. Stuart Lawrence Niven's signature, that's his seal, okay? Now I made the mistake of giving the originals to Jennifer and keeping the copies, but such mistakes happen. Clearly this is being presented to a jury. Clearly I had this done, and if you want to call Stuart Lawrence Niven to testify or make a statement, you're welcome to do that. So, lawful notice to the respondent, 24th of November 2009. Lawful notice to respondent, the human being calling herself Louise Henderson. So this was addressed to Louise Henderson, and what I'm doing now, I signed it under oath on the 24th of November 2009. I'm now reading it into evidence as evidence against Jennifer Marguerite Toll that this was served on Louise Henderson, and that on the 24th of November 2009, Louise Henderson was issued a default judgment of guilty for stealing my house. Therefore, on the 26th of November 2009, David Dunkley had no right to even be discussing or negotiating my house, which I owned due to this default judgment, okay, which I had claimed back correctly and properly through a claim of right. So I had issued my claim of right in September 2009. I'd served notice on Louise Henderson to prove that she had any right to sell my house and take the proceeds of my labour, which was my property, and put it into a bank account at Watts McRae and keep it from me. Okay? She failed to respond to that affidavit. I am quite happy to say under oath that she failed to respond to that affidavit, and this default notice was issued. From the time I signed this default notice, the Commonwealth of Australia had no lawful or legal right to do anything with my property. With the signing of this document, Louise Henderson was guilty of theft of my property. Okay? The 24th of November 2009. Now it says, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, hereinafter known as the respondent. Affidavit with respect to the unlawful theft and sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. So, firstly, principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavits and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address on the Australian Family Court in George Street, Parramatta on September the 23rd, 2009 and October 23rd, 2009. Principal makes oath that he is not in receipt of this lawful notice by return mail and therefore sincerely believes that the lawful notices were duly presented to the respondent. Principal makes oath that he has also sent many faxes to the listed fax number for the respondent in a further effort to offer the hand of peace in discussing and negotiating an amicable resolution to the issues at hand. The fax number used was 6102-9893-5600. Copies of the transmissions and receipt can be presented as evidence should the respondent wish. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120 and believes sincerely that none exists. Louise Henderson never presented any material facts or evidence to show that she had any right to retain the proceeds of that property. It has never been shown, not by Louise Henderson and later on not by David Dunkling. But remember, this is the date of this affidavit is the 24th of November 2009, 2 days before the court meeting, a default judgment saying that Louise Henderson had never shown this information. You can see that I've signed it. You can see Notary, Commonwealth of Australia. Okay? This was signed and notarized by a notary in the Commonwealth of Australia. So you people sitting on the jury, this is a legally binding document. It is a default notice. It's notarized by a notary in the Commonwealth of Australia. Louise Henderson owed me my house back. Okay? And this stands up in any court in the land, in fact. Now, you are a common law court. If you have a question as to the validity of this, you can discuss it with the expert in common law. He will tell you that it's valid. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the September 23rd, 2009 entitled Affidavit with respect to unlawful theft and sale of 8 Schofield Parade, Pennant Hills, between Margaret Nolan and Peter Andrew Nolan, and has received no response from a similar affidavit placed in the Royal Mail on October 23rd. Copies of documents provided are included in the envelope with this affidavit, and that's what I did. I gave her copies of those documents. The period for lawful response for both these affidavits has expired. Okay, so I offered Louise Henderson an opportunity to respond and say, show me the evidence you have for retaining the proceeds of my property, and that expired. In all systems of law, silence is consent. Non-response is to admit guilt. Okay, so Louise Henderson is guilty of stealing my house on the 24th of November 2009. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent irrevocable estoppel by acquiescence, barring the bringing of any future claim of defence against this default judgment. So Louise Henderson cannot defend this. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to provide proof of claim that she had lawful right to retain the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 21220, the respondent is hereby required to immediately, on receipt of this default judgment, issue the appropriate paperwork order to transfer all proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, an amount of approximately $290,000 held with Watts McRae, to the following bank account. And that was my St. George bank account at the time. Failure to immediately, meaning 5 p.m. Wednesday, 25th of November 2009, immediately, the next day. Failure to immediately obey this default judgment will result in a further remedy default judgment of $10 million being levied against the respondent to be paid from the respondent's personal property. Respondent is required to notify principal of the issuance of said paperwork via means described in the notice of communication and documented fax number immediately the paperwork is issued. No fax on that fax number will be interpreted that the respondent has refused to comply with its lawful default judgment. Both this judgment and this further remedy default judgment may result in one or more of the following. 1. A lien against the personal and commercial businesses and property of the respondent. A writ of execution to recover the amount of $290,000 from respondent's personal property. A writ of execution to recover the amount of $10 million from the respondent's personal property. Further, the respondent is hereby charged with the common law crime of theft. The principal shall, at his earliest convenience, empanel a court de jour and present facts of the matter to a court de jour. The court de jour will decide what penalty, if any, to impose on the respondent for the common law crime of theft. You can see I've signed it, and you can see that Stuart Lawrence Niven has notarized it. Okay? So the reason I wanted to read this into the record, and you can see the date, 24th of the 11th, 09. The reason I wanted to read this into the record for the case against Jennifer Margaret Toll is this document proves that as of the 24th of November 2009, ownership of the proceeds of the $290,000 thereabouts from the property of 8 Schofield Parade, Pennant Hills, was my property, even according to the legislation of the Commonwealth of Australia. Okay? My property. Nobody produced any evidence that said otherwise. So they defaulted, and that is my property. Okay? Now, next thing is I'm going to read the other 3 default judgments. You can see this, the first page is the same. This is the default judgment for the repayment of fees, I believe, for Philip Lee. Okay. So, lawful notice to respondent, Miss Jennifer Marguerite Nolan, with her address. I shall read the whole thing in again because this is testimony under oath. So, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age and competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, to state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to payment of fees to Philip Lee. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish mail as registered mail addressed to respondent at the current address of the respondent. That is the affidavit that you saw me read into the record just a little while ago. Okay? Principal makes oath that a short time later, said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian family law solicitors which continued to have the above address for the respondent. So it looks like the respondent returned the document returned to sender, refused to accept it, and you can't refuse to accept an affidavit. Okay, when it's delivered to you in your area, in your place of residence, that is served. If you return it to sender, that's your bad luck. Principal makes oath that he was subsequently emailed a financial statement. Oh, sorry. I just read that. So she was still living at the address. She just sent it back. So principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined and then sending the notice by registered mail. So I approached a professional service agent in Ireland and offered him €100 to deliver this document, and he said no because of the contents of the document. Okay, so I was required to send it by registered mail because, of course, if I turned up at Jennifer's house, she would call the police and have me arrested and thrown in jail. Okay, so she was sent. I tried to get a serving agent to serve it. I was refused. I sent it via registered mail. It was turned away. If I went there myself, I would most likely be arrested and incarcerated. So I made every effort to serve that document on Jennifer peacefully. She refused to accept it, and so you, the jury, can decide whether she should have accepted it or not. Okay? The principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed and serve the document himself. Jennifer has a history of having me kidnapped and incarcerated by making false allegations to police. 8. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called the police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. I make that under oath. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exists. Principal has not seen or been presented with any material fact or evidence that show responsible has any lawful right to retain possession of the fees which were legally and lawfully accumulated against the Instant Business Intelligence Company in an effort to defend the company from the actions of respondent and believes sincerely that none exist. So Jennifer has never produced evidence as to why she can do this, and she's required to produce evidence of that. In absence of evidence, I'm making the presumption that she can't do that. You can see that I have signed it. You can see it was the 24th day of November 2009 near Sydney, Australia, and you can see it was notarized by Stephen, what's his name? Notarized by Stuart Lawrence Niven. You can see it was notarized. Okay. Notary Public, Commonwealth of Australia, done deal. So, notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to payment of fees to Philip Lee and the attached notice of intent and proposed remedy issued by the principal and claimant addressed by the calling of Peter Andrew Nolan, a free man, within 10 days time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. The default judgment issued is that given the respondent was not willing to rebut the affidavit or apply her signature to pay the fees as proposed in the remedy, the respondent has hereby forfeited her right to being a signatory to the fees payable, and that the fees have become sole property of the principal to disperse the payment of these fees to Philip Lee. Meaning, I get the money from the house and I pay Philip Lee because she refused to pay Philip Lee. This default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. Okay? And authorised representatives of the private run-for-profit company calling itself the Australian Federal Magistrates Court is hereby instructed to issue orders to transfer the amount of $36,800, meaning 23,000 euros, to the following bank account. Okay? Meaning Louise Henderson, but she didn't do it. From this account, principal makes oath to forward the full amount to Philip Lee's solicitors. Okay, this amount was never transferred. You can see I've dated it again. Stuart Lawrence Niven has witnessed, signed, notarized. This document may be used in a judicial proceeding. That's what this is. This is now being presented to a common law court. That's what it's being presented to. This document is being used in a judicial proceeding. Next, this is a default judgment for the loan given to me by my brother Christopher. Okay, again, notice, and these, I will just say, these notices were handed personally to Jennifer in the court meeting. Okay, as she walked into the courtroom, she was served these notices, and I'm prepared to say under oath, I served these default judgments on her as she walked into the court meeting. So as she walked into the court meeting, she was served the default judgment for Louise Henderson that said, I owned the entire proceeds of the house. Okay? So before the court meeting, before she got into the room, she was served that default notice. And I want to make that very clear. Jennifer was in possession of the default notice that I owned the entire amount and property of the house before walking into the courtroom. Okay? So this is the affidavit with respect to repayment of loan by Christopher Nolan. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to repayment of loan by Christopher Nolan. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish mail as registered mail addressed to respondent at the current address of the respondent. The affidavit and notice of intent read previously into evidence. Principal makes oath that a short time later said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian family law solicitors which continued to have the above address for the respondent. Principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined and then sending the notice by registered mail. Principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed above and serve the document himself. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exist. 10. Principal has not seen or been presented with any material fact or evidence that shows respondent has any lawful right to retain possession of the personal loan made by Christopher John Nolan to principal and believes sincerely that none exists. So Jennifer has never presented any evidence that she had any right to retain the loan made to me by my brother Christopher John Nolan. You can see I have signed it. You can see it's the 24th day of the 11th month 2009, the 24th of November 2009, signed by Stuart, sealed by Stuart, a notary public in Australia. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to repayment of loan by Christopher Nolan and the attached notice of intent and proposed remedy issued by principal and claimant addressed by the calling of Peter Andrew Nolan, a free man within the 10-day time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any further claim against this default judgment. She has accepted this default judgment, that means. The default judgment issued is that the respondent was not willing to rebut the affidavit or apply her signature to repay the loan as proposed in the remedy. The respondent has hereby forfeited her right of being a signatory to the claimed money, and that the claimed money has become sole property of the principal to disperse the repayment of this loan to his brother. The default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. An authorised representative of the private run-for-profit company calling itself the Australian Federal Magistrate Court is hereby instructed, Louise Henderson, to issue orders to transfer the amount of $50,000 to the following bank account. That's my bank account number. From this account, principal makes oath to forward the full amount to Christopher John Nolan. Christopher John Nolan is reluctant to personally involve himself in these proceedings and wishes his bank account details not be made known to those who might well do him harm. Signed by me, 24th of November, noted by Stuart Lawrence Niven, signed by Stuart Lawrence Niven, sealed by Stuart Lawrence Niven. This document may be used in a judicial proceeding, which is exactly what is happening. Okay, so Jennifer waived the right to have her signature applied to this loan. She's stealing this $50,000. She stole this $50,000. So this one is for, just go down here. This one is actually for a gentleman by the name of, or a person, I believe it's a gentleman, by the name of Registrar Johnston. Okay, so when they stole my house, the person who signed the document to steal my house was one Registrar Johnston, Judicial Registrar Johnston. Okay, so this default notice was also sent to Judicial Registrar Johnston in this building. And I want to read this into the record in Jennifer's case because, again, this was sent on the 24th of November 2009, again notarized by Stuart Niven. So the lawful notice to the respondent, Registrar Johnston, and I'll read the whole thing. This is again to indicate that at the time, on the 24th of November 2009, the Commonwealth of Australia, as represented by the Australian Federal Magistrates Court, did not own my property, had no lawful claim to my property. Okay? So I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised, free sentient man, my yes be yes, my no be no, do state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself, him or herself, I don't know, Judicial Registrar Johnston, also acting in the judicial person known as Judicial Registrar Johnston, hereinafter known as the respondent. Affidavit with respect to order for the sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. This Judicial Registrar Johnston was the person who signed the order for the sale. Okay? The sale of the house, and had no right to do so. Never at any point had any right to do that. Okay? Because that right was claimed by deception. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address of the Australian Family Court in George Street, Parramatta. Actually, I sent it to the other building. Principal makes oath that this mail was never received at the return address and sincerely believes in good faith that this mail was presented to the respondent. So sooner or later we have to put Registrar Johnston on trial. The principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to refuse to pay his bill for the order that was issued and believes sincerely that none exists. So this registrar issued an order, I gave him a bill for that order, and he has not paid the bill. Okay, 6. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to order the sale of his house and believes sincerely that none exists. Okay, so I challenged Registrar Johnston to show me on what basis he or she had any right to sell my house, and they did not present any evidence of that. Okay? Now, Justin Dowd claimed time and time again that they had every right to sell my house, but the speech by Robert McClellan will put an end to that notion. Okay? Again, you can see I signed it. It was the 24th of November. You see Stuart Niven signed it, notarized it as a notary public, and stamped it. So the notarial notice of non-response and default judgment. Okay. To date, the respondent has given no response to the affidavit with respect to order for sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan, and the attached notice for bill of services ordered. Okay, so I sent him a bill of services ordered, issued by the principal and claimant, addressed by the calling of Peter Andrew Nolan, a free man, within the 20-day period. Printed copies are included for your information, so I packaged this up and gave it to them. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. That is, you're guilty. You cannot claim against this judgment. This default judgment is issued. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to pay his lawful bill for his lawful order, the respondent is hereby judged to have acquiesced to the bill for $5.5 million and this bill is now due immediately upon receipt. Immediate payment can be made to the following bank account, right? So I sent a bill for $5.5 million to Registrar Johnston. Okay, now of course he doesn't have that money. Okay, but this is where it's going to get interesting now, because you, the jury, can ratify this and say he didn't respond. He issued an order. He must find out the amount for his order before he issues it. Pay the $5.5 million. So failure to pay this bill on presentation of this default judgment may result in one or more of the following: a lien against the commercial, business and property of the respondent, a writ of execution to recover the amount of the bill from the respondent, common law criminal charges of theft to be presented to a court de jure, and for the court de jure to be charged with the responsibility of deciding innocence or guilt and subsequent punishment of the respondent for not paying his or her lawful bills. Okay? So that's what's going to happen to Registrar Johnston. But this is to note that having sold my house, I sent him a bill. You see me autograph. It's the 24th day of November, Stuart Lawrence Niven, his signature, stamp. Okay? This document may be used in a judicial proceeding, which is exactly what it's being used for. It is being used to present this affidavit to the jury that is putting Jennifer Marguerite Toll on trial for her part in the theft of my house. Okay? So that ends the reading of the default judgments. Thank you very much for listening. Item 8. Principal makes oath that based on all the above evidence, plus a great deal more evidence which could be presented, Principal formally and irrevocably accuses respondent of one crime. 1 count of common law theft for the retention of the proceeds of my 25 years of labour without any right to do so, thereby proposing to permanently deprive me of my property. Since today is the 25th of April 2013, and that order was signed on the 16th of the 6th 2008, it can be clearly seen that Judicial Registrar Johnston did intend to permanently deprive me of my property. It has been 5 years, right? Nearly 5 years. Next, you can see, Principal saith not, as good as a vow. I have signed this. I signed this on the 22nd day of the 4th month in the year of our Lord 2013. That is the 22nd of April 2013, near Karlsruhe, Germany. Please note that this affidavit has not been countersigned by people living in Germany. In lieu of countersigning, the Men's Business Association stamp has been applied to this page so as to ensure the veracity and authenticity of this document. Further, because Principal will read this affidavit into the public record and publish said record via YouTube, the public and the jury can be assured that the man making the allegations is Peter Andrew of the Nolan family, and that these allegations are in no way fraudulent. And here is the Men's Business Association stamp applied. Proposed remedy and notice of intent. As per the default judgment of 2009-11-24, the following is found. This final affidavit of accusation is petitioning the jury to ratify the following remedy instructions. Both this judgment and this further remedy default judgment may result in one or more of the following. 1. A lien against the commercial, business and property of the respondent. 2. A writ of execution to recover the amount of the bill, which being 5.5 million Australian dollars from the respondent. 3. Common law criminal charges of theft to be presented to a court de jure, and for the court de jure to be charged with the responsibility of deciding innocence or guilt and subsequent punishment of the respondent for not paying his or her lawful bills. What I mean by that is I gave a bill for $5.5 million to Judicial Registrar Johnston, that being 10 times the amount of which he deprived me. I want a writ of execution from the jury to recover that $5.5 million because Judicial Registrar Johnston has not paid his bill. Further, I would like a guilty verdict on the criminal law charge of theft, and for the jury to consider what punishment or remedy may be applied for this criminal act of theft. Okay? So Judicial Registrar Johnston had the opportunity to not be charged or accused of theft if he paid his bill of $5.5 million. He or she did not pay his bill of $5.5 million. It is more than 3 years later. 2009-11-24 is more than 3 years ago. Therefore, Judicial Registrar Johnston clearly intends to deprive me of my property permanently. He or she has not written to me in more than 3 years. So I would like a guilty verdict, please, for the crime of theft. Should the respondent not make the payment of $5.5 million from point 2, my apologies for the typo, then the principal petitions the jury to issue an instruction of incarceration or an outlawry writ for the respondent as the jury sees fit. So this person stole my house. If a man went into a convenience store with a knife and stole $300, you'd put him in jail for 2 years. Judicial Registrar Johnston stole my house with absolutely no lawful standing or legal standing to do so. And the question for the jury is, when you steal a man's house which sold for $550,000 and that was a depressed price, what is the punishment for stealing that house? What should that punishment be? And I would argue that the punishment for stealing a house by pretending to be a judicial registrar should be quite serious. Okay, that's what I would argue, and that's what I'm asking the jury for. So the jury should consider this seriously. The principal notes that in Australia the penalty for perjury seems to be 10 years when performed before the International Criminal Court, and that seems fair enough to me. We shall adopt the same standard for the MBA law courts in this case, since the precedent has been set. So if you go to this link, you'll see 268.102 perjury. 1. A person commits the offence of perjury if A. The person makes a sworn statement in or for the purposes of a proceeding before the International Criminal Court, and B. That statement is false. Penalty imprisonment for 10 years. Given that Judicial Registrar Johnston is a part of this legal system, I believe that 10 years for imprisonment for perjury is a reasonable thing to do, because that's what they would apply to me if I sat before the International Criminal Court and made a false statement, or I issued a false statement to the International Criminal Court. Well, the MBA is just another court, just like the International Criminal Court, and so I claim the right to have the penalty of imprisonment for 10 years for perjury. Therefore, I say the respondent is well advised not to commit the crime of perjury. Now, respondent has until 2013-05-17 to make one of the following actions. 1. Admit his or her crimes and pay the proposed remedy payments as outlined above. 2. Refuse to reply to this affidavit of accusation and thereby accept a default judgment of guilty as accused, and have the jury review the evidence to determine its veracity, and then to issue instructions as the jury sees fit, with no defence from respondent offered. The jury instructions will then be processed according to the due process of law. 3. Reply to this affidavit of accusation, contesting the accusations and contesting the items presented under penalty of perjury and full commercial liability, noting that the penalty for perjury appears to be 10 years jail in Australia. The length of incarceration or the withdrawal of the protection of the law is to be a matter for the jury to decide. And here it is. I have signed it, 2013-04-22. This concludes the reading into the public record and reading into evidence of the affidavit of accusation presented as a lawful notice to Judicial Registrar Johnston. Thank you very much for listening. One last item we will add to this video stream prior to the closing remarks for the presentation of this evidence into the public record and into the evidence for this jury is a dinner speech by Robert McClellan when he was the Attorney General of Australia. This dinner speech was delivered in 2009-02-20. That's the 20th of February 2009. That is 9 months before the notices and default judgments were sent to Louise Henderson. In this speech, you can clearly see that Robert McClellan makes clear that the writers of the Australian Constitution thought best to leave common law property rights to the protection of the common law and not to deal with property rights in the Constitution. Therefore, Robert McClellan is agreeing with my position that I had the right to claim my property under common law. And Robert McClellan cites a whole series of cases which talk about the Magna Carta being the basis of Australian law and the fact that a man cannot be dispossessed of his property without a jury of his peers and a fair trial, or the due process of law of the land, that being the common law. So clearly I was dispossessed of my property without due process of law, and this is quite obvious, and anybody who looks can see this. So I want to present this after dinner speech by Robert McClellan to the jury for your consideration and understanding, so that you can comprehend that common law property rights are protected by the Magna Carta and common law, and that the Constitution of Australia does not override the Magna Carta or the common law. Okay, so here is the speech by Robert McClellan being read into the record and into evidence for this jury. Now I will read into evidence a speech made by Robert McClellan when Robert McClellan was the Attorney General for Australia. So you see the logo there. This was taken off Robert McClellan's website, off the Attorney General's website. You can see that there. Okay. The speech was on the 20th of February 2009 at a Constitutional Law Conference, and you will see in this speech Robert McClellan clearly indicate common law and the Magna Carta is superior to the legislation of the Commonwealth of Australia, and it is the foundation of the legislation of the Commonwealth of Australia. So, Mr. Jury Member, I will read exactly what it says and I will make commentary during this presentation, but please remember who said this and when. This was Friday, the 20th of February 2009, 8:15. This was some 10 months before November the 26th, 2009, which was my appearance in the Australian Federal Magistrates Court. Okay? This 20th of February predated my 26th November meeting by 10 months. So this is what Robert McClellan said 10 months before you saw the video before the video was created in that court. So Robert McClellan says, "First may I acknowledge the traditional owners of the land we meet on and pay my respects to their elders both past and present." Other acknowledgements. Who said? Associate Professor Andrew Lynch, Gilbert and Tobin Centre for Public Law, University of New South Wales, Sir Gerald and Lady Brennan, Sir Anthony and Lady Mason, the Honourable Ian Callanan and Mrs Callanan, Justice Mitchell Gordon, Federal Court of Australia, Justice John Hayden, High Court of Australia and Mrs Hayden, distinguished guests, ladies and gentlemen. So, a Justice of the Federal Court, a Justice of the High Court, people who should know what the law is around this place, right? And this is what he said. As many of you will know, the Australian government, through a committee of eminent Australians, is currently consulting the people of Australia on the recognition and protection of human rights. With limited exception, our Constitution does not recognise individual rights, freedom or guarantees. In Kruger v. Commonwealth, 1997, Justice Dawson said, quote, "Those who framed the Australian Constitution accepted the view that individual rights were best on the whole left to the protection of the common law and the supremacy of Parliament. Thus, the Constitution deals almost without exception with the structure and relationship of government rather than with individual rights, unquote. Okay? Justice Dawson in Kruger v. Commonwealth 1997 said, "Those who framed the Australian Constitution accepted the view that individual rights were best left to the protection of the common law." Okay? Which is the jurisdiction that I claimed. And the Constitution deals almost without exception with the structure and relationship of government rather than with individual rights. So when David Dunkley was talking about inalienable rights is an inanity, this is what he's talking about. He's talking about common law, and he's talking about the Magna Carta and the Bill of Rights of 1688. He then goes on to say, nevertheless, in dealing with the structure and relationship of the government, the Constitution does protect some fundamental individual rights. These rights are said to arise from, quote, silent constitutional principles, unquote, that are part of our public heritage. That constitutional heritage includes the English constitutional instruments, Magna Carta and the Bill of Rights. Okay? So these rights are said to arise from, quote, silent constitutional principles that are part of our public heritage. That constitutional heritage includes the English constitutional instruments, the Magna Carta and the Bill of Rights, 1688. Let's remember who's saying this. Robert McClellan, February 20th, 2009. Attorney General. Okay? That is who said Magna Carta and Bill of Rights. Tonight, and so you, Mr. Jury Member, and you, the general public, if you bother to actually investigate and review the evidence before you make up your mind about this, you have in front of you the Attorney General of Australia telling you that the Magna Carta and the Bill of Rights is in force and protects individual rights in Australia according to the Australian government. Okay? That's what he told you. Tonight I would like to reflect on how the first of those English constitutional instruments has had a profound impact on the development of fundamental rights, namely the right to due process, and he means of law, and the right of citizens not to be arbitrarily deprived of their property. Okay, the rights of citizens, now citizens is another deceptive term, but the right of citizens not to be arbitrarily deprived of their property. What did David Dunkley do? He made up rubbish that he pulled out of his arse, and he arbitrarily deprived me of my property. That's what he did. Okay? And you saw it in the court order. He goes, oh, I'm going to vary this by 22% on the basis of probabilities. Not evidence, the basis of probabilities. That's what he said. Okay? So, namely the right to due process and the rights of citizens not to be arbitrarily deprived of their property. In doing so, I will endeavour to avoid what one writer has described as the unsatisfactory compound of, quote, a mixture of legal dogma and legal history. So Magna Carta, Robert McClellan says, Magna Carta is generally regarded as the origin of that principle which underpins the Westminster system, the rule of law. Its significance to Australia is recognised by the fact that a copy of the Charter is displayed in our federal parliament. As an aside, according to modern values, it could be argued that the Charter is voidable because on the 15th of June 1215 it was obtained under clear duress from King John. But Magna Carta was subsequently confirmed by 7 kings, and its principle has been repeated from generation to generation. There can be no doubt that the barons, clergy and foot soldiers who so pressured King John intended the document to be of great significance and intergenerational in its impact. Chapter 1 sets out that King John granted to all freemen, quote, all the underwritten liberties to be had and held by them and theirs and of us and our heirs forever, unquote. Forever, unquote. In chapter 61, the king also committed that he shall, quote, procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished. And if any such things has been procured, let it be void and null. Not a bad job of entrenching, I must say. So, David Dunkley was representing the king, the government. And the Magna Carta says, the king also committed that he shall, quote, procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished, and if any such thing has been procured, let it be void and null. Okay? So what David Dunkley did is void and null according to the Magna Carta, which he has to abide by. Okay? The charters have had significant success. Their intentions have been fulfilled, at least in respect of those matters I have mentioned. The due process of law and resistance to arbitrary deprivation of property. Well, not in my case, obviously. Due process of law. Unquestionably, the most significant clause of Magna Carta is contained in Chapter 39, which has been interpreted as saying, quote, no free man shall be taken or imprisoned or diseased or outlawed or exiled or in any wise destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or by the law of the land. Quote. That's Robert McClellan saying that. Was I diseased of my property? Was I in any wise destroyed? Was I set upon without lawful judgment of my peers? I think so. Over time, the phrase the law of the land evolved to become due process of law. The earliest formal use of that term is in a statute in the year 1354-28 with Edward III, which provided that no person should be condemned without first being brought to answer by due process of the law, or in Norman French, due process de loi. There has been extensive writing and indeed controversy about the evolution of this crucial term. But I think it is fair to say that the evolution of the phrase is significant because it became more than a mere descriptive of law of the land. Instead, due process became a fundamental concept and principle which has both informed the development of the law and tempered its application. So, was I afforded the due process of law? And the answer is, of course not. I was not afforded the due process of law. You have got the video in front of you and you can answer yourself, was I afforded the due process of law? And you can only answer no to that, because I asked many times over for the agreement to step onto the ship and to negotiate the situation, discuss the situation, and I was denied the opportunity to step onto the ship with all my inalienable rights intact, therefore being denied due process of law. So now here we are 3 years later, and we're getting due process of law, right? In the Australian context, in R versus McCullough, ex parte ratu, Justice Murphy specifically credited Magna Carta as a foundation of natural justice and due process, saying, quote, the doctrine of natural justice is not a modern development. It is traditional in most English-speaking countries. It is an aspect of due process traceable in English law, at least back to the Magna Carta, unquote. Right? That's an Australian justice. In Abner versus Official Trustee in Bankruptcy, 2000, Gleason, C.J., McGower, and Hain, J.J. said, quote, fundamental to the common law system of an adversarial trial is that it is conducted by an independent and impartial tribunal. Perhaps the deepest historical roots of this principle can be traced to the Magna Carta, unquote. You, my dear sir, sitting on this jury, are part of an independent and impartial tribunal. You know, this is the fundamental to the common law system of adversarial trial is that it is conducted by an independent and impartial tribunal. That's what you are sitting on this jury. Okay? There remains debate as to whether there is an implied constitutional right to a fair trial in Australia, at least at a federal level, but it is nonetheless arguable that a fundamental principle of due process is integral to Australia's constitutional heritage and the development of Australian jurisprudence. Okay, well, I don't think there is a debate as to whether you have a right to a fair trial in Australia. I don't think that's up for debate, and if you on the jury say it's not up for debate, then it's not up for debate. 14. It might seem that at a deep level in the court's jurisdiction that Chapter 3 of the Constitution, the separation of judicial power, presents a barrier to any, quote, bill of attainder or quote, bill of pains and penalties. Even at state level, it might be seen in concerns about legislation pertaining to the Parliament to direct the detention of a person for the purpose of punishment when their guilt or innocence has not been determined by a court. And it might be seen in the determination to uphold the discretion of courts to stay proceedings where an unfair trial would otherwise result. 15. Interestingly, the principles of Magna Carta are echoed beyond the criminal jurisdiction. In Groves versus the Commonwealth in 1981, the High Court determined that a member of Australia's armed services could not be prevented from pursuing an action for negligence against the Commonwealth in circumstances where he was not involved in armed conflict. This was, the court said, because he may not have the benefit of Chapter 29 of Magna Carta. Justice to him can be denied by the courts. Unlike the rest of the community, he is excluded from what Sir Edward Coke described as the right of every subject, that he may, for injury done to him by another subject, take his remedy to the course of the law and have justice and right for the injury done to him. Okay? So Magna Carta was reflected into the military area. Now 16, deprivation of property. Okay? Australian courts have also recognised the historical foundations of Australian constitutional bulwarks against arbitrary deprivation of property. Well, not in David Dunkley's arbitrary Australian Federal Magistrates Court, it's not. Okay? 17. In the Communist Party dissolution case in 1951, the High Court said that as at the date of the Constitution, quote, the King had no power by the exercise of his prerogative to dissolve bodies corporate or unincorporate or forfeit their assets to the Crown or to deprive his subjects of their contractual or proprietary rights. Such an action on this part would have been contrary to Magna Carta and the subsequent acts reaffirming Magna Carta referred to in Halsbury's Laws of England, 2nd edition, volume 6, page 450. Okay, that's what that case said. That is not to say, as was made clear in the Communist Party dissolution case, that a person or entity could not be deprived of their property by a valid law of the Commonwealth Parliament. However, as was explained in Clooney's Ross versus Commonwealth 1984, quote, an executive power of acquisition of land for a public purpose is different in nature to a legislative power of a national parliament to make laws with respect to the acquisition of land for a purpose in respect of which the parliament has power to make laws. See Magna Carta, clause 29, unquote. The exercise of legislative power under Section 51 of the Constitution is, of course, conditional on just terms compensation. That precondition, I would argue, stems from the victory that the barons and clergy and people of England had over their monarch on the 15th of June, 1215. Let me read that again. The exercise of legislative power under Section 51 of the Constitution is, of course, conditional on just terms compensation. That means if David Dunkley steals my property, pretending to use the Constitution, he must compensate me on just terms. And that those just terms are 1 million ounces of gold. That's what he agreed to, and you heard him say that. The issue of proprietary rights of the individual is interesting because it is an area that a possible merging of the principle of Magna Carta and the primary international human rights instrument, the Universal Declaration of Human Rights, can be detected. And I just want to point out the Australian federal government does not consider itself bound by the Universal Declaration of Human Rights, regardless of what they tell you. They have not agreed that they are bound by the Universal Declaration of Human Rights. It's only been 60 years, but they haven't wrapped that into the Australian Constitution yet. Okay? For example, in Newcrest Mining 1997, Justice Kirby referred to Article 17.2 of the Universal Declaration, which provides that, quote, no one shall be arbitrarily deprived of his property, unquote. I was arbitrarily deprived of my property by David Dunkley. Okay? And here's Justice Kirby in 1997, citing the Universal Declaration of Human Rights, which provides that no one shall be arbitrarily deprived of his property. His Honour described the roots of Article 17 in the following terms, quote, whilst this article contains propositions which are unremarkable to those familiar with the Australian legal system, the prohibition on the arbitrary deprivation of property expresses an essential idea which is both basic and virtually uniform in a civilised legal system. Historically, its roots may be traced as far back as the Magna Carta 1215, Article 52, of which provided, quote, to any man whom we have deprived or dispossessed of lands, castles, liberty or rights, without the lawful judgment of his equals, we will at once restore these. So let me quote the Magna Carta, Article 1215, Article 52 again, which provides, quote, remember David Dunkley took my property arbitrarily on the basis of what he called probabilities, not evidence, quote, to any man whom we have deprived or dispossessed of lands, castles, liberties or rights without the lawful judgment of his equals, we will at once restore these. Quote, you people I am presenting this to are the jury. You are bound by the Magna Carta. This jury is formed in common law, and the Magna Carta says, okay, and I'm going to repeat it again because you've got all this evidence in front of you. The Magna Carta says, to any man whom we, meaning the king and his agents, meaning David Dunkley, whom we have deprived or disposed of lands, castles, liberties or rights, meaning lands and castles, meaning money, my house, you know, a man's house is his castle, they stole my house, liberties or rights, without the lawful judgment of his equals, we will at once restore these. Was I given the lawful judgment of my equals? No. Therefore, they are bound by the Magna Carta to we will at once restore these. You, the jury, are bound by the Magna Carta to at once restore these things that I had stolen from me, unless you, David Dunkley, can prove that he had the right to do this. Absent any proof, you are bound. You have no choice. You are bound to issue remedy instructions to restore my property to me. Okay? 21. His Honour adopted similar reasoning in Malika Holdings Proprietary Limited versus Stretton 2001, where he said that, quote, the Universal Declaration of Human Rights, Article 17, like the Magna Carta 1215, Clause 52, treats as fundamental the rule against arbitrary deprivation of property, unquote. Some may say we are seeing a merging of ancient rights and ancient constitutional principles with developments in international law. Just as an aside, I wonder if the people in Cyprus are reading this, right? These ones about to have their bank accounts arbitrarily looted. 23. It is not my intention to enter that debate, save insofar as I will invite you to consider the words of Justice Brennan in Mabo versus Queensland No. 2, where he said, quote, the common law does not necessarily conform with international law, but international law is a legitimate and important influence on the development of the common law, especially when international law declares the existence of universal and fundamental rights, unquote. I appreciate that there is a difference of opinion as to the extent to which fundamental international human rights principles have influenced and continue to influence the development of the common law. The same common law that Justin Dowd claimed was not in force in Australia, right? The president of the New South Wales Law Society claims this common law that the Attorney General is talking about, that all these justices are talking about, was not in force in Australia. That shows you how criminal Justin Dowd is. I would suggest, however, that this will inevitably be the subject of ongoing academic and adversarial debate. In particular, our friends across the Tasman are also engaged in the debate. For instance, Cook P, as he was of the New Zealand Court of Appeal, said that it is, quote, the duty of the judiciary to interpret and apply national constitutions, ordinary legislation, and the common law in the light of the universality of human rights, unquote, and the common law. Conclusion. 25. Given this controversy, and in closing, I will leave you with a question to which there will no doubt be a range of responses around the room. The question is, Should the Parliament by legislative action or the Executive by administrative action or practice do anything to guide or influence that evolution of this important debate? An interesting challenge for Justice Brennan's son, Father Frank Brennan, who is presently chairing the government's National Human Rights Consultation. I look forward to hearing what you and all Australians have to say on this issue. And it ends. All I can tell you what I have to say on this issue, Robert McClellan. I issued notices to you about the crimes committed against me in December 2009 when you were the Attorney General. Given this speech and the fact that I was arbitrarily deprived of my property, one wonders, Mr. Robert McClellan, why you did not take an interest in my case. Anyhow, I'm sure you'll take an interest in my case when I put you on trial. All right? So this concludes the reading into evidence of Robert McClellan's dinner speech from the 20th of February 2009. Thank you very much for listening. And now we come to the closing remarks for this case against Registrar Johnston. I have presented near 3 hours of video for you to review and evidence for you to look at. Some of it is extra over and above what is absolutely necessary. But I think it's important that the jury see and understand the broader picture and the crime that Registrar Johnston committed inside this broader picture, which is the fact that the legal system in Australia is a criminal cartel and that Registrar Johnston is fully aware of this. As has been presented in the evidence, you have seen the order, specifically by Registrar Johnston, claiming that I consented to the sale of my house and claiming that if I didn't consent, he could cause my house to be sold by having other people in his criminal cartel sign paperwork on my behalf. So claiming that somebody consents to something with the threat that if you don't consent, we'll do the paperwork for you anyway, is hardly consent, right? That's not agreement. So you have seen the order that Registrar Johnston signed. You have seen the affidavit sent to Registrar Johnston and the bill sent to Registrar Johnston, and you have seen the default judgment signed and duly notarized by Stuart Niven, and then that was forwarded to Registrar Johnston. So you've seen that I participated in the complete due process of law. You also saw a presentation, a speech by Robert McClellan, that clearly states that the Magna Carta is the basis for the government of Australia, and the Magna Carta says that you cannot be deprived of your property without a jury trial of your peers or the due process of law. And Robert McClellan puts in many cases of judges talking about the Magna Carta and the due process of law and how property rights and other rights are protected by the Magna Carta, and that the common law is specifically used to protect property rights in Australia. You saw Robert McClellan say that. Okay? So you have my evidence before you. Obviously, I don't know what evidence Registrar Johnston may put before you, but the only evidence that matters is evidence which is presented and sworn under oath. I have presented this affidavit sworn under oath, and I'm prepared to back it up with any more evidence that is necessary at the actual trial process. And the jury may ask questions, and I shall present more evidence under testimony, and more evidence and testimony under oath at the trial for any questions that any jury member would like to ask me. The evidence that you may or may not be presented by Registrar Johnston, you must also take into consideration, but you must only take into consideration that evidence which is presented under oath, penalty of perjury and full commercial liability. Now, I would like to leave you to your deliberations. You need to go away and think about what you've been presented with and come back with your decision. And lastly, I'd like to say thank you very much for your jury service. It is very much appreciated. I certainly hope we can reintroduce the rule of law into our land known as Australia. Thank you very much for listening.